Let me tell you about a workplace discrimination case that started with what some people call just banter. It involved comments like Paddy, potato, and I'm not going to mention the other ones. And this ended in an employment tribunal finding racial harassment and victimization. What makes this case even more interesting is that it also exposes a huge misconception people have about discrimination law, because many people think that racism can't be or happen to white people. But UK employment law says something different. Now, this case involved the employee who experienced repeated racial comments linked to stereotypes about Irish people. And over time, I've mentioned these sorts of phrases that were used: paddy, potato, and some other worse ones. Now, something important happened during the tribunal hearing. At times, the employee appeared to laugh along with the comments. That was the evidence on behalf of the employers. And the employers sought to rely on that as a defense. They'll say, well, they joined in with the banter, but the tribunal rejected that argument. The judge accepted that sometimes employees laugh at things because they feel uncomfortable or want to fit in. Now, that doesn't mean that the conduct is welcome. When the tribunal looked at the pattern of comments over time, it concluded that the behavior created a hostile and humiliating working environment. And that meant that the conduct crossed the line into racial harassment under the Equality Act. Now, under the Equality Act, harassment happens where there is some unwanted conduct related to a protected characteristic, and it has the purpose or the effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And race, under the law, does include nationality and ethnic origin. So, discrimination doesn't just mean skin color. It also includes being treated badly because you're Irish, Polish, Scottish, English, or from any other national background. And that's why the tribunal had little difficulty concluding the comments in this case were linked to race. But that case didn't just stop at harassment. After raising concerns about discrimination, the employee later faced disciplinary allegations of gross misconduct. The tribunal examined those allegations and found that parts of the evidence relied on by the employer were simply unreliable. And crucially, the tribunal concluded that the disciplinary action had been triggered by, at least in part, because the employee complained about discrimination. And that, legally, is known as victimization. So under the law, employees are protected from retaliation, as it's often called, but in legally speaking, we call it victimization, if they raise discrimination concerns or assert their equality rights. And so the tribunal upheld both claims, harassment and victimization. Now, this case also highlights a huge misconception around discrimination law that I hinted at earlier. A lot of people believe white people can't experience racism, but the Equality Act does not work like that. The law protects people from discrimination because of race, which includes nationality and ethnic origin. So if someone is targeted because they are, for example, Irish, Polish, Italian, or another ethnic or national background, they can absolutely amount to racial harassment, even if everyone involved is white. The law doesn't look at who is part of the majority or the minority. It looks at whether someone has been treated unlawfully because of a protected characteristic. So why does this case matter? Well, race discrimination claims are brought to the employment tribunals every year, but they're actually very difficult to prove. Tribunals look closely at the evidence, the witness credibility, and the full workplace context. So when a claim succeeds, it usually means that the tribunal has found clear evidence that the behavior crossed the legal line. And many of these cases start exactly the same way, with something people dismiss as just banter. The real reason here is that workplace culture matters. What one person thinks is harmless humor can be deeply humiliating for someone else. And when these comments repeatedly target someone's nationality, their ethnicity, or another protected characteristic, they can become unlawful harassment. For employers, that creates serious legal risk. And for employees, the law provides protection when workplace behavior crosses the line. At Magara Law, we regularly advise both employees and employers on workplace discrimination, harassment, and grievance issues. If you're an employee experiencing discrimination at work, we can help you understand your rights and guide you through the legal process. If you're an employer dealing with a complaint, we help you on fair investigations, lawful disciplinary procedures, and reduce the risk of tribunal claims. So if you're dealing with a workplace discrimination issue, you can contact us here at Magara Law for confidential advice. And if you want more videos explaining your rights, well, make sure to subscribe, because understanding the law is the first step to protecting your rights at work.